50 years ago, the United States Supreme Court handed down what may be the most important decision of the 20th century. Brown v. Board of Education declared in May 1954 that separate education facilities are inherently unequal. Separate but equal would no longer be the law of the land. To explain this historic event and its 50-year aftermath, we have James T. Patterson, history professor at Brown University and the author of Brown v. Board of Education, A Civil Rights Milestone and Its Troubled Legacy, published recently by Oxford University Press. We're talking with Professor Patterson today from his Providence, Rhode Island office. Welcome, Jim Patterson.
Thank you for having me.
Let's begin by setting the stage for this decision. What was America like in 1954, especially when it came to issues of race?
Well, it was, of course, the Jim Crow era of segregation in the South and in the border states and in some other states. It separated blacks and whites in those states by law, as opposed to the de facto segregation which often existed elsewhere. In all of these states, for instance, with regard to schools, which is what the Brown case concerned, of course, there were 17 states that required the racial separation and segregation of black and white students, and 4 other states, including Kansas, which is where the Brown case came from, which permitted local areas in the state to impose it. This affected millions of children and was the anchor, really, of the much larger Jim Crow segregation system, which affected not only schools but everything else, public accommodations, restaurants, hotels, even drinking fountains and telephone booths. So it was a very harsh system of separation, which also carried with it discrimination, which is to say the separate but equal facilities were separate but unequal.
And that would certainly apply to schools.
Yes.
Unequal. Can you elaborate on that a little bit? Some examples?
In the South, for instance, in the 11 states of the old Confederacy, it was estimated in the early 50s, when this litigation was reaching the Supreme Court, that the black schools in the South received about 60% as much per pupil as the white schools did. And I should point out that the white schools in the South generally were much poorer than the schools outside of the South. So these were very, very poor schools, often without central heating, leaky roofs, tar paper roofs, wood stoves, poorly educated teachers, very dated hand-me-down textbooks, and so forth, and very crowded facilities. It was very difficult to get any kind of a decent education in most of those schools. And in my book, I'm not very nostalgic about these places.
Well, thank you very much, Jim. James Patterson, Brown University, talking about his book, Brown v. Board of Education, A Civil Rights Milestone and Its Troubled Legacy, published by Oxford University Press. Thank you, Jim.
Many thanks.